A chain-smoking former journalist named Moore somehow came to be working in the communications department of the Department of Justice in Ottawa. The Justice Building, where the federal government's lawyers were located on Parliament Hill, was distinguished by its high, steep copper roof and sandstone exterior. Unlike Moore's former profession of investigative journalist, he had at this point in his career settled into a kind of semi-retirement by accepting a position as head of the communications unit at Justice, charged with its communications rag, inter pares, and the internal and external communiques, which were the bread and butter of PR. He was compelled this day, as part of his duties, to attend yet another meeting of Justice Senior Council gurus and mandarins, this time presided over by the Deputy Minister himself. Rather than debating substantive policies, law reform, or the great political and legal issues of the early 1980s, the government lawyers, senior counsel, and bureaucrats were doing their usual quibbling, ad nauseum, on the precise esoteric lingo to use in yet another mission statement, setting out, or trying to set out, in painful, technocratic, and managerial detail, the values, or so-called values, of the department, as if justice wasn't itself a sufficient value for these types. As the draft took shape, the lawyers somehow managed to leave out the bigger picture entirely, with language devolving into increasingly low levels of minutiae. After several hours of this, Moore had had enough. He slammed his fist onto the table and yelled, "It's the Department of Justice, damn it, not the Department of Law." And there you have it. Law and justice are not the same thing. The law is the vehicle. Justice is the ostensible goal, end point, or at least until modern times that was the assumption. In the UK, a Department of Justice only came into being and took that name fairly recently, in 2007. This is not to say courts didn't deliver impeccably just decisions long before that. As far back as, say, Lord Mansfield directed the jury to find that the stolen jewels taken by the young and very sympathetic accused were in fact valued at less than £5, knowing full well the penalty for theft over £5 was death. The jury happily obliged, and there have been just decisions long before that and since. In the modern Western state, naming the hub of government's management of the law, policy, prosecutions, constitutional and interstate affairs, and oversight of the courts, the Department of Justice, may also serve a public relations or marketing purpose. Much like the Department of War was renamed the Department of Defense in many countries in the West after World War II, to give the management of the forever wars into which liberal governments have been engaged ever since a softer sell. In this first part of a two-part series on law and justice, or what I think will be a two-part series, we'll see, I will look at the political and social forces that have effectively toppled justice as the apex value of the legal system, and replaced it with social goals that do not regard perfect justice as a necessary or even desirable outcome of a legal system. I will look at how so-called social justice and the fight for equality have left the legal systems in Western countries remarkably tolerant of injustice, provided the desired social goals are pursued. The lofty utopian goals are, of course, never met, which is why the cycle is perpetual. If there is injustice, it is mere collateral damage. When Lord Lloyd wrote about law and justice in the early 1960s in his book The Idea of Law, he sought to describe the type of society in which law and justice will thrive as follows. Law needs to be related to the system of values recognized in the particular community in which it operates. Such a system of values may, and in fact does, differ from place to place and from period to period. Though it may be impossible, as the positivist is disposed to think, to demonstrate the absolute superiority of any particular system over all others, actual or possible, nevertheless, if a community believes that its values are the highest attainable, it will clearly judge the existing law in accordance with those values and try to amend or adapt it where it falls short of them. It may be said, however, that this is all very well as an approximate description of how law tends to function, at least in enlightened communities, which enjoy a fair degree of harmony as to their basic aims. But there is a more general purpose that the law everywhere aims or should aim at achieving, and that is justice. The idea of law, it may be urged, has always been associated with the idea of justice, and if it is agreed that this represents the ultimate goal to which the law should strive, then we can arrive at the purpose of law more directly, without becoming entangled in the value of particular societies with all their conflicts and uncertainties. For, after all, are not those values themselves, so far as they seek to be embodied in the laws of the community, merely an individual expression of the general striving towards justice itself? First question, does anyone agree any more on the ultimate goals of the law? It may have been agreed to in the 1960s, but in 2024, is it possible to say any more that we have agreement on what the ultimate goal of the law is? In the multicultural cities of the West, is it possible to find anything resembling a, and I quote, fair degree of harmony as to basic aims, close quote? And what of the ascendancy of power theories of law, like critical legal studies or the Marxist theory of law, which permeates the bloodstream of the intelligentsia, bureaucracies, professional associations, and the judiciary itself? Once there has been a shattering of common values, common morality, and a fair percentage of the population currently supports governments that see law's purpose as the suppression of dissent, the destruction of political enemies through selective application of law, and select prosecutions and penalties, where are you likely to find justice there? As I've said before, and will say again, even in the most dysfunctional of legal systems, shattered by disagreements on the most basic values, and provided the particular issue or dispute is devoid of political content, there are just decisions rendered all the time, and that will continue as long as there is a true court system. But what about those more and more frequent cases where law confronts politics, race, gender, ideology, and hot-button global policies? We may begin with the proposition that justice is a moral value. In the natural law way of thinking, it may be seen as one of the essential goods. Plato in his Republic places justice at the summit of the moral world. This wasn't difficult to see in the homogeneous city-states of ancient Greece. The famous dialogue in the Republic, led by Socrates, would undoubtedly have gone a very different direction were the setting one of the woke cities of the West today. The ending for Socrates, however, would undoubtedly have been the same, although given the state of our cities, he may have been happy with exile. In the Republic, Plato sets out to explain what is meant by justice. For Plato, there's an inevitable coincidence between a just city, ruled by a just man, and whether the city is made up of just citizens. If a city is unjust, run by a tyrant who acts only in his own interests, there will be no just men living in that city. That is just the way it goes, and that may well explain a lot about the tolerance for bad government in the modern cities of the West today. Plato's conception of justice is essentially minding your own business, that, and I quote here, everything or person has its proper sphere, and that justice means conforming to that sphere, close quotes. Plato's conception of justice is based on the aristocratic idea that every person is inherently adapted to some specific function, and that if he departs from that function, he's guilty of injustice. Of course, that would certainly be true if those without the intelligence or natural skill to be doctors are made doctors by some law, or the swords and shields of the army are made by incompetent political appointees of the state. All this will seem very unjust to the doctor's patients, or soldiers on the battlefield, whose swords and shields fall to pieces. Lloyd adds, this somewhat resembles the feudal idea of the three orders of society, priests, warriors, and laborers, each with their own self-contained function. Plato goes beyond medieval feudalism in that his philosopher kings would be selected not by birth alone, but by ability and then specially educated. A striking difference from modernity is that the ancient Greek conception of justice centers around the evident inequality of people. With the Enlightenment and great ideological revolutions of the 18th and 19th centuries, justice was overtaken by a new supreme value, that of equality. This, as we will see, had the effect of turning what constitutes an unjust state on its head. If the example of the terror during the French Revolution were not enough, we now have many more examples of the negative effects of imposing equality as a supreme social value on civic life. Given the good press equality continues to get for some reason, the outcomes it is producing will seem to many counterintuitive. Equality is supposed to be nice, compassionate, liberating. It is anything but. Alexis de Tocqueville noted early on, equality has meant the destruction of the estates, guilds, classes, and other associations, which had, by virtue of the very inequality they conferred on the population, represented limits on the power of the king. The foremost, or indeed the sole condition required in order to succeed in centralizing the supreme power in a democratic community is to love equality, or to get men to believe you love it. Thus, the science of despotism, which was once so complex, is simplified and reduced, as it were, to a single principle. Despotism and equality have a close kinship. If indeed, as the revolutionaries thought and continue to think, that justice is simply the rich and powerful, including such evil and nebulous entities as the patriarchy, getting what they want, equality will have to be imposed. The corrective to justice is what we call today social justice, which imposes the interests of the so-called victim classes over the previous ruling classes, professions, business types, mass corporations, and the working classes alike. What exactly is social justice? The implication is a kind of perpetual social struggle, but what is lost in this struggle is any attempt to re-examine or inquire anew concerning that core question asked by Plato in the Republic, what is justice? The external criteria to assess the conduct of the ruler, in our case, progressive rule, is forgotten or rather shelved in favor of the maxim that the ends justify the means. If the leveling policies like DEI, diversity, equity, and inclusion, produce unfairness, well,
it doesn't matter.
In Plato's Republic, Polemarchus takes up the conventional view that justice is giving a man his due. Socrates is critical of this definition, pointing out that giving someone his due isn't always just. You could give the example of resisting giving a lunatic the weapons you owe him. Such exceptions aside, Polemarchus's definition isn't all that bad. Thrasymachus, however, takes what will sound today to be a very modern position, and a realistic one, that justice is, in effect, the rich and powerful getting what they want. Professor Scott Mason of Tyndale University makes the interesting point that advocates of social justice today are, in effect, siding with Thrasymachus.
It's a very cynical perspective, but it's the perspective that I think we hear about a lot right now in terms of social justice. That phrase is used a lot. And the suggestion in the social justice movement is that justice, as we are experiencing it, is never just. It's always to the advantage of the rich and the powerful and the privileged, etc. That's what justice is. That's what the social justice camp says. And therefore, we need to rectify that injustice by some sort of social political means. Okay? But they're agreeing with Thrasymachus.
As equality or leveling replaces justice, you can begin to understand state policies that seem terribly unjust, at least to some of us, but are permitted to exist and spread as they have a fundamentally leveling effect. Two obvious recent examples. The dominant religion in the West remains Christianity, even in an attenuated, customary, and non-practicing form. Thus, as Christian churches are burnt in places like Canada and France, there is little outcry and little, if any, attempt to investigate or prosecute. Why is that? The reason is simple and to be found in equality theory and social justice. As the social objective is to see the dominant oppressor religion put in its place, church burning is both payback for past alleged wrongs, but also serves to allow other creeds to move in and become more vocal.
And it is fully understandable, given the shameful history that we're all becoming more and more aware of.
Next, a migrant to a nation in the West should, in an ideal Platonic world, occupy the lowest rank in society, if part of the society at all. He has contributed nothing, and would historically be happy, and indeed could expect no more than a cot in a military barracks and repatriation when the political situation back home stabilizes. But what we see across the West is immediate access to housing, interest-free loans, loaded debit cards, free medical care, all looking very permanent. How is this fair? The media and politicians may point to international agreements, all they want, but that is just window dressing. There is much more going on here. First, Canadians, for example, whose families have been in Canada for, say, generations, have undoubtedly paid into the system in labor taxes, military service, and contributing young citizens to the nation. This gives them, to a progressive egalitarian way of thinking, an unfair advantage, especially since progressives continually challenge the legitimacy of this original occupation. There needs to be leveling in the progressive way of thinking, and this is what migrant policies do in a spectacular way. But what does this have to do with justice? Law and justice is replaced by law and equality, and law and injustice. If an injustice occurs, well, that's understandable, because political factors such as historic injustice and systemic failures of the system call for reallocations. Social justice is very much a perverse form of distributive justice in the Aristotelian sense.
It doesn't matter.
Next, I want to look at formal justice and equality. Long before substantive equality was enshrined as the ultimate value in the West, in bills of rights, charters, and human rights codes, and progressive political philosophy, we had the idea of equal treatment. This is an ancient notion that likes should be treated alike. The basic idea of formal justice is that the law is supposed to be applied equally in all situations and to all persons to which it relates, without fear or favor, to rich and poor, to powerful and humble alike. A law which is applied without discrimination in this way may be regarded as the embodiment of justice. But of course, minors and mentally incompetents should probably not be treated equally, and do well to have their rights curtailed or their affairs managed by court order until they reach the age of majority or regain their senses. Although I'm sure today there will be some objectors out there, if not already, as this is a violation of perfect equality and may have to be undone, whatever the consequences.
It doesn't matter.
Likewise, depriving a non-citizen or prisoners of the vote didn't used to be a controversial notion. It is very much so today. But if police and prosecutors choose only to investigate and prosecute offenders, depending on the race of the perpetrator or the creed of the victim, we are no longer seeing equal treatment. U.S. Supreme Court Justice Robert Jackson warned about prosecutorial discretion in his paper, The Federal Prosecutor, back in 1940. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated. He can order arrests, present cases to the grand jury in secret session, and on the basis of his one-sided presentation of the facts, can cause the citizen to be indicted and held for trial. He may dismiss the case before trial, in which case the defense never has a chance to be heard. I've used the term anarcho-terrorism or the anarcho-terrorist state to mean the selective application of laws based on a political agenda or political criteria. In no way does this satisfy the criteria of equal treatment or formal justice, but it may well be an aspect of social justice in the eyes of progressives, a necessary tool to fight enemies of equality. Formal equality is largely seen today as an empty vessel compared to the real powerhouse of the equality movement, equality of outcome. Another tool in the arsenal of equality of outcome is lawfare, selective prosecution of political enemies with the purpose of harassment and financial ruin. Often these cases are simply dropped before trial. The punishment is the prosecution, and it can be very effective. Another recent example is to ignore practice and custom in prosecution and sentencing, and to proceed with a wink from the government to a swift trial and the imposition of very stiff penalties. This is the fate of those considered Class A political enemies. Here we see a breakdown of the notional division of powers, which is nonsense anyway, with the judiciary serving to advance the interests of the executive, communicated often publicly through mass media. But perhaps one of the more troubling effects of social justice and equality theory is the breakdown of what would, until recently, have been seen as a natural response to crime in the population, and more particularly, the response of a parent to the death of a child or vice versa. There is nothing more natural and ancient than demands by family members for justice in the case of an assault, injury, or wrongful death inflicted on a family member. What we see more and more, however, and more frequently today, is a remarkable neutralization of these senses, the relegation of justice for the victim to a lower rank, with parents, for example, advocating the interests of the perpetrator in the name of equality and social justice. This is obviously a powerful social phenomenon of almost religious intensity. As Michael Rechtenwald has written, once beliefs are unconstrained by the object world, the possibility for assuming a pretense of infallibility becomes almost irresistible, especially when the requisite power is available to support such beliefs. In fact, given its willy-nilly determination of truth and reality on the basis of beliefs alone, philosophical and social idealism, for which postmodernism is infamous, necessarily becomes dogmatic, authoritarian, anti-rational, and effectively religious.